better. Well, thank you. A few days ago, they filed a notice of appearance that they were going to step in and take over representing the state in this case. And then yesterday, so they're 4 days into the case, they file a motion for a new execution date. And this is obviously very alarming because we have a pending appeal, and this is not an appropriate time under Texas law, nor does it make any moral sense, in my view, to be seeking an execution date when someone's raised serious claims of actual innocence and brought a whole bunch of evidence to back it up. I am unaware of any death penalty case where the attorney general has stepped in and then turned around and immediately sought an execution date. It's unheard of as far as I know, and especially when an appeal is pending and they obviously aren't familiar with the case. What is appropriate under state law, that any DA in a criminal case can ask for the attorney general to step in. And usually that's like, oh, will you take over trying this case? That perhaps people in that county don't have the resources or experience. But for them to come in after years of the case being handled by the local district attorney and just step in and immediately then jump to this extreme measure is completely shocking. So the attorney general cannot set an execution date in Texas. That's left to the local court, and we don't even have a judge assigned to this case. So they filed this motion, and we now have objected today that this is not appropriate under state law, considering the pending appeal, to be seeking an execution date. And second, we don't even have a judge. And third, these new lawyers don't know this case. And quite frankly, based on representations that have come out of the Attorney General's office since the last execution date was pending, it's clear they do not know the case. They have not read the trial record. They don't know the new filings. And so to have people that are unfamiliar with the case take over and then seek an execution date, I think should be really troubling to the citizens of Texas. And so we're fighting back against that. It's not legally appropriate. And, as I firmly believe, it's not morally appropriate either. After someone has been convicted under federal constitutional law, they always have a right of habeas corpus, which is to try to appeal to a court to let them back in and try to present new evidence or rely on new law to get another chance to be heard. And in Texas, that's governed by statute. And there also is this new science habeas vehicle that we have tried to rely on repeatedly, because the Texas Court of Criminal Appeals itself has now found that the science that was used to convict Robert is deeply flawed. They've rejected the shaken baby syndrome hypothesis that was used to convict him. And the same expert who testified in that other case testified in Robert's case. So it's not even, they're somewhat similar. These are completely similar causation theories that now modern science has rejected. It's like certainly there are still plenty of medical practitioners, virtually all would say you shouldn't be violently shaking a child. But the theory was you could imagine that a child had been shaken, although no one had observed anything, based on things you saw internally. And that has been rejected. And so we are continuing to challenge that. But we also have all this new evidence of the other facts about Robert's daughter's condition that show there was a leap to a conclusion that is no longer valid, but there are other explanations that show that there was no crime. He had a painfully sick little girl who needed medical attention, and when he couldn't explain what had happened, he was simply accused. What one would hope is that all of the information that did come out, particularly through these public hearings before the legislature, and we're talking a bipartisan committee where every one of them was convinced Robert's conviction was wrong. And most of them believe he's already established his innocence. So all that public airing of information that instead was in a bunch of boring legal documents, we hope that would make a difference. Plus, we've actually found yet more experts who have looked at the case and identified other things. I mean, that's how complex the situation is, but there's just like nothing left there of what the case relied on at trial. And meanwhile, you have the Attorney General's office that does not have the history of the case, and I fear has not familiarized themselves with the new evidence, um, who were trying to thwart these hearings and trying to stop Robert from being heard. And one must ask, if there's such confidence in this case, why all the effort to shut it all down? Why not allow the new evidence to be considered? And so I ardently hope that what will happen now is the Court of Criminal Appeals will be allowed to do its job, and this will stop being a matter of, political gamesmanship, which is unfortunately what it feels like, even though I am certainly not a political actor, nor is poor Robert. So. Well, they're two different things. What has happened is it's already at the Court of Criminal Appeals, so there should be no execution date. But now we're going to have to fight to prevent a trial court from setting that date, which then will disrupt the normal flow here. So we have asked to be heard. We hope that when a judge is assigned, we will have a chance to argue against there being a date set, because under Texas law, this was not a proper process. So it's like a date shouldn't be set. What should happen is the appeal goes forward, the new evidence is considered, and then we still hope there's a chance of Robert getting a new trial. No, I have not heard of a specific date, and that just sent chills down my spine, because, of course, the last time they were seeking to execute him was October 17th. So again, this seems to me more to be about some other thing other than getting at the truth. It seems about to be about political theater, when a man's life is at stake, and the very integrity of our criminal justice system. I mean, this is not just about Robert and the fact that he was wrongfully convicted using discredited science. It's about what can we expect for all of us out of a criminal justice system when you're talking about the most serious power anybody can have, asking permission to kill somebody in the name of the state. I have not been able to speak to him. I have sent messages to him, and by sheer accident, one of his spiritual advisors was headed to visit him today. So I was able to tell her, and I'm hoping she's providing him with some comfort. But I'm sorry, but that's one of the very painful things about this work. I can't just pick up the phone and call my client and explain something. And I'm talking to you about a very vulnerable client, a client who has a lifelong developmental disability, who has cognitive impairments. This is just going to be such a devastating blow to him. I was just there last week trying to give him hope that things were on the right track, and then this happens. Well, I can't go into, the details, and most of our conversation is often about his family, his loved ones. His wife recently got to have several visits with him, and he was sort of heartbroken that she had to go back to Germany. He's has a brother who's ill. I mean, that's most of our conversation is his concern about his loved ones and his inability to be out there and helping them more. We talk very little about his case, just me, reminding him the fight goes on. What's at stake here is the truth, and the truth has gotten lost here. The truth is his very ill, beloved little child collapsed in a way that he was not able to explain to medical professionals. And his inability to explain was viewed with suspicion. And part of this is because children don't collapse that often, thank goodness. And so that's part of the whole sad story of shaken baby syndrome is it is a hypothesis that was born of trying to explain devastation, that when infants and young children suddenly seem to collapse, what could explain this? But science has moved on and come to see that that explanation is profoundly flawed, because this internal condition that Nikki had is explained by many things, including accidental short falls when you hit your head wrong, and viruses, and many genetic disorders, including pneumonia, which we now know she had, which was never diagnosed. So this is a child ill her whole life who collapses, and her father, who had fought to have her in in his life, is accused. And he's this poor guy living on the edge of town who doesn't speak so well, and he gets a lawyer who says, "Oh yeah, this must be shaken baby," along with everybody else. But the highest court in this state has said, looked at the science from that era and said it does not hold up. And yet Robert is still fighting for a new trial. And there have been a lot of misinformation about him and his case. But those who have looked at it, looked at the facts, have been profoundly shaken by it. And I think that was the power of what we saw in the fall with our lawmakers, taking the time to learn a case and present it to the public, with some experts, with some of this history. It's complicated stuff, but that is democracy. That was beautiful. What has no place is political maneuvering being used to try to influence the court system. One thing that I think was unsettling to me was, and important though, was to hear from the local district attorney who was seeking Mr. Robertson's execution, and realizing she herself was not very familiar with the case. And she hadn't tried the case. And it was clear from her response to the questions from lawmakers who had studied the case that she was not up to speed on the new evidence. And I think that is a problem when the whole point of habeas proceedings is to get a chance to put on new evidence. If you have someone relying on what happened 20 years ago and saying, well, that's the truth, the whole point is what was treated as true at that unfair trial does not hold up. And we should have leaders who are completely familiar with the facts before I think they go off and try to seek something as serious as an execution date. Well, she has now removed herself. So that's the district attorney has stepped aside for the AG, and they're now the ones asking a court to sign a death warrant. And that's a document, believe it or not, that you need to be able to have permission to kill somebody. Um, a judge has that authority, and under state law, the judge should not be entertaining that request when there's the kind of appeal pending that we have. So it's at the very least premature, but I think profoundly improper. What happens next is a question mark, but one hopes that there will be a court proceeding and the rule of law will prevail. And we should all hope for that and watch for that. And that would mean there's a hearing in a courtroom before a judge who gets educated about the law and the two sides' arguments about this execution date. And we see it unfold for the public because courtrooms are places of public interest. This should not be happening, in secret, you know, through mechanisms that nobody's aware of. So that's my, I'm sorry, I'm not being very articulate here, but I really do think sunshine is what is needed here. Light shining on this perplexing and troubling new development. Now, I just thank you for your interest in Robert's situation. He is a man deserving of compassion and basic due process. And that's all we've been fighting for is a chance for a fair trial. Nobody has to decide for themselves right now if he's innocent or not. I'm thoroughly convinced, but I've studied the evidence. I've studied the case now for nearly 10 years. But the right of the most humble of people, a dirt poor guy with no education and no resources, he deserves justice as well as the richest person on this planet. That's America. Thank you so much. Bye bye.